Three ways to leave your home to your kids. The third way is the best. My name is Michael Pevney. I am an estate planning lawyer in Southern California. I create estate plans for California families, and I practice all over the state. And so in this video, I'm going to talk about the three most common ways that people leave their homes to their kids. And we're going to talk about the pros and cons of each of those. And please follow this page for more estate planning information. And if you have any questions about estate planning or probate, you can visit my website, ocestateplanlawyer.com. You'll also find it in the description. So method one is giving your home to your children. You can do this while you're alive, and you can be assured that once you give your home to your kids, that they now own the home. So essentially, you legally transfer ownership by drawing up a new deed, either a quitclaim deed or a grant deed, putting the home in the name of the kids now. So there's some pros and cons to this. First, a good thing is that it will avoid probate entirely. Now let's remember what probate is. Probate is the court-controlled, government-supervised, judge signed off on asset distribution program. It's expensive and it takes a long time. So where I practice, if you pass away and you don't have a will, or even if you do have a will, or you have no estate plan at all, your home, your property has to go through probate. Good chance it might end up with the kids, but that might be after a year and a half or 2 years. This method will avoid probate, and it can simplify your estate plan if you don't have that many assets. Maybe your home is your largest asset. So here are the downsides to just giving your home to your kids while you are alive. Taxes, capital gains tax. So let's say that your home you bought a long time ago for $200,000, and now it's worth $1 million. If you gift that home to your children or child, they are going to be, when it's time to pay capital gains tax, when they sell the home, they are going to be responsible for the capital gains as if they purchased the home for the price you purchased the home. So if you pass away, you're gone. They're going to be responsible for $800,000 in capital gains. There are ways of figuring out capital gains tax. Yes, it is a type of income, but it's taxed a little bit differently. Second drawback to giving your home to your kids: you don't own your house anymore. You don't control it. The kids can sell it. The kids can take a loan out on it. They can rent it out, and they can, yeah, it is literally theirs. They can do whatever they want with it because it doesn't belong to you anymore. But it does give the home to the kids. Method two would be adding your children's name to the deed of your home. So let's say my wife's name is, well, my wife's name is Heather, and the home, if our home is named in Michael and Heather as joint tenants, if we just wanted to name our single child, we have 2 kids, but let's say we have a single child, and all 3 of our names are going to be on the deed, and it is going to be held as a joint tenancy with a right of survivorship. What that means is the last person standing, meaning the last person to be alive, owns the home. So there are some pros to this. First, it doesn't have to go through probate. It doesn't have to go through court. Once people pass away, you essentially have to file a death certificate and an affidavit with the county records office in California. Most counties, it's called the clerk recorder's office, and that just removes now the dead person from the deed to that home. And the person or people left on the deed now own the home. If you have multiple kids and both parents pass away, now they are joint tenants and they have equal rights to that home. Maybe there can be some conflict if one child wants to sell the house, one child wants to live in the home, and that can be an issue because, frankly, how many of you out there have seen when multiple children inherit a home, one wants to sell in it, one wants to live in it, one wants to rent it out as an income-producing property? That can cause conflict. And in California, depending on if a child is living in the home, there is a risk of property tax, a property tax reassessment. Much like just giving your home to your kids, there is an issue of capital gains because, again, the tax basis upon which capital gains will be assessed will be the original purchase price of the home. Where I live, there are plenty of people that paid $50,000 for their home, and next to that home, there are people that paid $1 million for that home. Because the first people that paid 50 were original owners 40 years ago. And so we want to avoid the capital gains taxes once the kids who now have control of that property want to sell that home. What we're looking for is a step up in basis, which placing your child's name on the deed is not going to accomplish. So in a situation like that, we are looking at literally hundreds of thousands of dollars in capital gains tax that can be avoided. Third drawback to putting your kid on the deed to the home, you lose some control, not all control, but the children are co-owners, meaning that they could sell their half, they can take loans against it, and that home could, if they don't live in it, be open to lawsuits, to bankruptcies, and that puts that home at risk. So the third, and in my opinion, best method, especially if you live in California, of getting the home to the kids that is going to avoid all of those drawbacks is placing the home inside of a trust and making the child the beneficiaries. So I believe that for most people in California that either own some sort of real estate or have kids that are under the age of, I'm going to say 25 to 30, should create a trust, a revocable living trust as their main estate planning document, sort of the centerpiece to that estate plan. So what we do is, again, my wife's name is Heather, we would transfer the home from Michael and Heather to Michael and Heather as trustees of the Michael and Heather Living Trust. Now this trust, it's a document. And inside of that document has very specific instructions about what's supposed to happen when you pass away. But before you pass away, you maintain control over that trust. There are not going to be property tax issues if we put it in, if it's your primary residence and you have the same ownership interest, you have complete control over that trust while you're alive. You can sell it. You can take loans out on it. You can add more property to that trust. It is essentially legal control very similar or the same as the control you have over it when you initially bought that house. The children, while you're alive, have no rights to that home at all. So what happens when you pass away, when both of you pass away, we now grant that home with the children as the beneficiaries. They now get access to that home or the right to live in it, or they just get control of that home. First, similar to the other two ways of transferring a home to the kids, it avoids probate. It does not have to go through court. Again, it's a couple of document filings with the county records office, essentially an affidavit that these people have passed away, along with a death certificate. And if there are children living in the home, the home's not going to be reassessed for property taxes in California. Yes, property taxes tick up a teeny bit every year, but the $50,000 home that was purchased 40 years ago is not going to be reassessed at its current $1 million value. And a huge issue is this capital gains issue. So remember we talked about a $50,000 home and a $1 million home. What there is when you leave the home to the kids in a situation like this is there is what is known as a step up in basis. So when a home passes to kids by way of a trust, it would be as if the kids purchased that home for that $1 million. And if they sell that home shortly after the passing, after the death of those parents, there will essentially be no capital gains taxes at all, because it will be as if they bought the house for the value that it was at the time of the passing of the parents, or of the second parent. So what are the bad things about trust? Well, you got to do some planning, right? And you typically want to set up this with a qualified estate plan lawyer. I'm not a huge fan of document preparation services where you essentially fill in the blanks and they spit some stuff out to you, and you have to go through the motions of drafting a deed, filing that deed with the county. A qualified estate planning lawyer is going to be able to give you advice, legal advice, personalized legal advice. But of course, a cost comes to that. Obviously, I cannot quote you a specific price unless you speak to me and unless you hire me. Everybody's situation is totally different. But what I can tell you is that it is 99.9999%. I hate giving promises online, but it's going to be a lot less than the cost of probate, and a lot less than the cost of the capital gains taxes. So those are the three often used methods for getting a home to a child: giving the home to a child, putting the child on the deed to the home along with the parents, because remember, that's going to both of those methods are going to give control and to the child while they're alive, and have the capital gains issue. And the third best way to leave a home to a child is to place it inside of a living trust with the parents in control of things while they're alive, and passing things on to the kids when they pass away, so we don't have any capital gains issues. So once again, my name is Michael Pevney. I am an estate planning lawyer in California. If you have any questions about this or anything else related to estate planning or probate, you can set up a time to speak with me for free by going to my website. It's going to be in the description. Follow this page for more estate planning information, and I appreciate your time. I appreciate your attention.